Okay.
All right, we're calling this meeting to order. It is. Okay, well, we'll do that a little bit better. We're going to call this meeting to order. This is the regular meeting and the reorganization meeting of the Franklin Township Planning Board. It is Wednesday, January 16 at 7:36 p.m. My name is Jim Clarkin. I am the current attorney for the board, and I am opening this reorganization meeting for the sole purpose of electing a chairperson. But in the interim, we will read the Open Public Meetings Act notice. In accordance with the Open Public Meetings Act, adequate notice of this regular meeting of the Planning Board has been provided. Pledge of allegiance. I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
And for the record, we administered the oath of office to three of our board members, the fourth being absent. We'll move to the reorganization section. At this time, I'd like to entertain nominations for the position of chairperson.
I hereby nominate
Close enough.
I would second Dr. Orsini.
All right, I'll call out for any other additional nominations. Are there any? Hearing none, the nominations are closed. Can we call the roll, please?
Godwin Amalola. I'll just go down the line. Mustafa Manzray.
Yes.
Robert Mettler.
Yes.
Robert Thomas. Do I call him if he's nominated? Oh, Mike Orsini.
Yes.
And Ted Chase.
yes.
Jennifer Ragnow.
Yes.
And Carl Houck.
Yes.
I like a man who believes in himself. Congratulations. The meeting is yours.
Thank you, and thank you, everyone. So, yeah, I was actually just in the office to sign some paperwork the other day, and I was talking to Vince, and she said, how long has it been now? And I think we came up with something like whenever you were elected council first time. That's what we came up with. 2011? 9. Oh, see? Time flies when you're having fun.
I was still in high school then.
This will be your 10th year?
Yeah, 10th year. So, wow, I wouldn't have guessed that myself unless Vince brought it to my attention. So thank you, everyone. It's a pleasure once again. We can move on to the nomination and selection of vice chairperson. So floor is open for nominations. I will nominate, even though she's not present tonight, Cecile McIver.
I'll second that.
Are there any other nominations? Hearing none, the nominations are closed.
Godwin Amalola.
Yes.
Mustafa Manzray.
Yes.
Robert Mettler.
Yes.
Robert Thomas. Mike Orsini.
Yes.
Ted Chase.
Yes.
Jennifer Ragnow.
Yes.
Carl Houck.
Yes. Okay, excellent. I'm sure Cecile will be back relatively soon from her
Yes, she just asked to be
medical leave.
excused.
And so we wish her the best and Happy New Year if she happens to be watching us. The appointment of the planning board attorney. So we have one RFP from the firm of Clarkin and Vignulo. According to our bylaws, we are, of course, required to interview. We have James Clarkin here. And I will ask a question, are you able to serve as our planning board attorney?
I am continuously able to serve, as is my son-in-law and partner, Peter Vignola.
Okay. Are you qualified to practice in the state of New Jersey and qualified in planning board law?
My license is still active, hangs on the wall, and I try and do everything not to endanger it. Excellent.
And just to let the public know, the firm of Clarkin and Vignola has been our planning board attorney for the past several years. I'll open it up to any other questions from the board for Jim. Okay, seeing none, I thereby nominate the firm of Clarkin and Vignulo as planning board attorney for the Township of Franklin.
Second.
Godwin Amalola.
Yes.
Mustafa Manzray.
Yes.
Robert Mettler.
Yes.
Robert Thomas. Mike Orsini.
Yes.
Ted Chase.
Yes.
Jennifer Ragnow.
Yes.
And Carl Houck.
Yes.
Both Pete and I appreciate the opportunity to serve, and we're grateful for your vote.
Well, thank you, and you've done an excellent job for us, and we really appreciate it. Look forward to working with you for yet another year. We have to do the roll call.
No.
No, okay. So we'll move right into the minutes. So the minutes for the regular meeting of December 12th, 2018.
Mike, you missed
We
the
have a
witness
witness
oath.
oath.
Sorry? Oh, sorry, did I skip that?
Yeah.
Go ahead.
You want me to, okay. So I guess what we're doing is raise your right hand. Do you solemnly swear that all of the testimony that you will give in all of the matters before the Franklin Township Planning Board in the calendar year 2019 will be true to the best of your knowledge and belief? Thank you.
Excellent. Again, the nomination or the approval for the minutes of December 12th. I will make a motion to approve.
A second?
Yes, Ted?
I want to note one correction, which is that I am listed as neither present nor absent. I was in fact absent for December 12th.
Well, thank you for that correction. So with that, again, move the minutes as amended.
Godwin already second. Does he need
Okay.
to second it
Second,
again? Okay. Councilman, oh wait, you weren't there. Carl Hauk,
Yes.
Robert Mettler,
Yes.
Mustafa Manzray,
Yes.
Jennifer Ragnow,
Yes.
Godwin Amalola,
Yes.
and Chairman Orsini.
Yes. 2019 Planning Board Calendar, it's in your packet, with the cover sheet that says resolutions, which are right after it. We have to vote on that, or do we?
Calendar?
Yeah,
Yes.
we do? Okay.
Place vote is fine.
Okay, so I move that we approve the calendar as written. Can I get a second?
I'll second it.
Okay, all in favor?
Aye.
Opposed? Okay, calendar carries. Resolutions, 500 Pierce Street LLC, PLN 18-00012. And I will make a motion to approve.
Second that.
Councilman Chase,
Yes.
Carl Hauk,
Yes.
Robert Mettler,
Yes.
Robert Thomas, Jennifer Ragnow,
Yes.
and Chairman Orsini.
Yes. Somerset Properties, PLN 18, or 08-00015. So I'll move to approve that as well.
Second.
Councilman Chase,
Yes.
Carl Hauk,
Yes.
Robert Mettler,
Yes.
Mustafa Manzray,
Yes.
Robert Thomas, Jennifer Ragnow,
Yes.
and Chairman Orsini.
Yes. And last resolution, Shahada and Chen, PLN 18-00002. And I will move that as well.
Oh, you're killing me.
Have a second from anyone?
Second.
Excellent.
Councilman Chase,
Yes.
Carl Hauk,
Yes.
Robert Mettler,
Yes.
Mustafa Manzray,
Yes.
Robert Thomas, Jennifer Ragnow,
Yes.
and Chairman Orsini.
Yes. Next is discussion of our bylaws. Actually, there's not two of them. There should be bylaws, BY, but yeah, go right ahead.
Okay, so these are relatively straightforward. They were provided in your packet. The first change under the category of order of business, frankly, just reorders. This outlines the agendas for the board, and the bylaws weren't consistent with how we actually do it. So we just moved this around to reflect the order of our actual agendas in 2019. Section entitled Minor Subdivision Committee. In reviewing the bylaws, I noticed that This describes the minor subdivision committee and their role. In the ordinance, under the ordinance, the minor subdivision committee can actually approve a minor subdivision that does not have any variances. In the bylaws, it basically said the minor subdivision committee reviews it and then recommends to the board. But that's not in fact how the board has done it, for the last 10 years or more, because again, that's what's in what's actually in the ordinance. So this reflects the ordinance that the minor subdivision committee can review and approve minor subdivisions without variances that aren't associated with any other application. So if it was a minor subdivision associated with a site plan, that would be heard by the full board. But if it's just a standalone minor subdivision with no variances, the minor subdivision committee, again, can approve it. Lastly, listing of vouchers paid. This is the discussion that we had last month, which was due to the change in the law that, the prompt payment law, I believe it's called, that we have to pay within 45 days. Rather than having items, for example, the monthly retainer put on the planning board's agenda for approval before we pay, this would allow the staff to pay those payments after we notify the chairperson to that effect. And then afterwards, we would put notification of those payments on future agendas so you're aware of the bills that are being paid on your behalf. This would require, and all the rest of the bylaws would remain unchanged. Councilman Chase has a question.
I notice what a significant change here, that public comment is placed after the hearings, and I think it should be before the hearings, so that the public does not have to wait through all the hearings to make a comment that's not necessarily related to the.
Well, that's not a change. Now, the board can have that discussion. That's been the format of our agenda. So the format of the agenda has been that public comments have followed. But, well, maybe, I was looking at your.
That hasn't been what we've been doing.
I removed hearings only because the reorganization and the oath was so long that adjournment was on the page by itself. So I removed it only because we didn't have any.
I was following that one agenda. So we'll put public comment after, we'll make that item E. So that would be after the resolutions and before discussion items. I think that's probably the appropriate location.
Yeah.
Yeah, I would agree with
This
that.
is way down here.
Yeah, public comments.
Yeah, I mean, because that's for public comment on anything that doesn't have its own hearing, so, yeah, that should probably be, I agree, yeah, it's after approval of resolutions. And then we
Thank you
do
for
the
catching that.
public comment, then discussion items, then we go into
Yeah,
everything.
It's just that it should be before the hearings.
You're 100% correct. We'll make that change. So
Okay.
with that change, I don't know if there's any other questions. Otherwise, this would be a vote.
I had a couple of comments, if I could. Do we have a checklist?
Applications, yes, that's part of the ordinance.
Part of the ordinance, all right, so
Yes.
it doesn't have to be in the bylaws.
No, it's in the development ordinance.
All right, fine. On Rule 2.1.2, at the top of the page, it says, "The board reserves the power to request additional information." That's being struck?
No. I think you may be going by a previous draft that I had sent to Peter.
To Peter? Okay.
And we're not, all of those different changes. The only changes that are being suggested at this point are on that one sheet.
Are on this one sheet?
Yeah.
All
So
right.
the input from Peter Vignola, there were some, a larger type, amount of changes, and he thought that there might be some, he didn't suggest some of them, so I just simplified it. And again, it's only boiled down to these three changes here.
Okay. Then this sentence is going to stay in, and it says, "The board reserves the power to request additional information not shown on the application or plans at time of hearing." I would just suggest that we say consistent with the checklist requirements. And there's a recent case on the checklist, and that's why I'm saying that. Okay, the court made it very plain, all right, that you can only ask for whatever is consistent with what your established checklist requires.
Is that at the time of completeness, but even the board can't ask for additional information if some additional issues come to light?
The answer is, it still has to be consistent with the checklist. And just about anything that you would ask for would be consistent with the checklist.
Checklist is
I think
pretty
it's
inclusive.
broad.
Yeah, okay?
So what section is
I would
that?
just, this is 2.1.2. Okay? And it's the sentence that says that the board reserves the power to request additional information. I would just say consistent with the checklist.
So does the board get that? Right now, it says the board can request additional information, and the suggestion is to add consistent with the checklist.
Yeah, I mean, that's fine. I mean, I don't have any issues with that.
And then, I don't know, because I don't have the latest, there may have been a stray phrase that should have been struck out, but I'll talk to you about it later.
Yeah, I mean, we can always go back and at another meeting, make other changes in any
Oh,
time.
yeah,
So
you
it's
can.
not a
Yeah.
big deal. But the changes tonight really are just the ones that are on this one sheet.
Yep.
So you still have a question, Ted? Go ahead.
Another thing about the order of business, you have listing of vouchers paid at the very end, and specifically after executive session. I think, at the very least, executive session should be the last item in the order of business, because if we go into executive session, which we don't very often, we ask that the recording be turned off. So any other action should be before going into executive session. And I would think listing of vouchers paid would be up there right after discussion items.
Well, the reason we're changing that is because we're doing it a little bit differently, which is consistent with Rule 4.46, which we talked about at the last meeting, which was we're no longer going to individually approve vouchers for like the planning board attorney every month. Those are sort of like, that we nominated him, that's his fee, we know that's his fee. If it goes up, then we'll reopen it. But because of this 45-day issue about payment, and that's true of anything that is taken out of escrow.
Well,
Now, if there's something that we're getting done on our own, like we want an expert and we're hiring it, and it's not coming out of escrow, it's something a township is going to pay for, just to, use it for instance, then, we could talk about it. But, I don't know, Mark, if you want to explain it, Ted, you weren't at the last meeting, so you probably
Well,
missed all
I
this.
understand the whole business about listing of vouchers. I'm purely talking about where it is in the order of business.
I agree that it should be before executive session. Now, we wouldn't, even if we go into executive session, we're sort of suspending the meeting. We're not adjourning it. We come back, we come out of execution, and then we adjourn it. So adjournment should still be last.
Yeah.
So I think it should be the way it is, but take listing of vouchers paid and put it before executive session, then executive session, then adjournment. Yeah?
Right above executive session?
Yeah, because that way we'll get all that done before we have to go into executive session, and in most cases, that won't apply anyway. So,
Well,
and then,
I assume that the listing of vouchers usually will just have a piece of paper listing them,
yeah, exactly.
so that it in a
But if
way,
there's
it doesn't
anything-
even need to be in the order of
Right,
business.
but in case there's anything we need to discuss, we should still keep it in there, and it should be, as you say, I agree with you, that it should be before the executive session.
I envisioned, it would basically be on the agenda as Christine has them now, but instead of, it would probably say, September, what's the term? The monthly retainer.
Right.
And, the chairman may make note of it as part of the proceedings and then move on to the next agenda item. So it's noted on the record, but you just move on. It's not it's not necessarily on there for the board discussion and vote.
Yeah, to me, the logical place to put it would be up with discussion items. I agree that we're not normally going to discuss it, but if there's a chance of discussing it, it probably should be right there with the discussion items.
I don't care. That's fine. It just should be before executive session, and
Yeah.
the executive session and adjournment should be the last two things. After that, I don't care where you put it.
We'll put it up, that's fine.
Yeah, I agree. The important thing is to be before executive session.
Okay. So, now that we have that squared away, any other questions? No? Okay. Then, I'll make a motion that we accept these changes to our bylaws.
Councilman Chase,
Yes.
Carl Hauck,
Yes.
Robert Mettler,
Yes.
Mustafa Manzray,
Yes.
Robert Thomas, Jennifer Ragnow,
Yes.
Godwin Amalola,
Yes.
and Chairman Orsini.
Yes. Okay, last item business is, since we had a little bit of time tonight, Mark asked to just go through a brief work session item related to the master plan, which is the zoning map. So, Mark?
Mr. Chairman?
Yes.
Even though there's no
Oh,
one
right, right,
here,
right. You're right.
I would like to move that we open the
Yes.
meeting to the public.
Let's do that. I second. All in favor?
Aye. Seeing no one coming forward, I move we close the public session.
Second.
All in favor?
Aye.
Okay. No, thanks, Bob. Work session, new business, yeah, so.
Yes, so this ordinance would change the zoning in three different areas. There was, if you recall, during the master plan reexamination done in 2016, there are a number of recommendations to look at the zoning or change the zoning in different areas. These three changes were chosen for this ordinance because the recommendations didn't necessarily require additional analysis and study. It basically said you should rezone it to these zoning districts. So I kind of picked these out as, I guess low-hanging fruit or kind of maybe, easier ones to do without further study. The first one is in the area of the Canal Walk development. When the Senior Citizen Village District was created back in the 90s, it rezoned the entire area bounded by Schoolhouse, Weston Canal, and Metlers and Weston as one big, that whole super block is Senior Citizen Village. But not the entire, that entire block was developed as Canal Walk. So there are these 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13 properties, most of which have homes on them that are in the Senior Citizen Village zone, but obviously aren't Canal Walk. So they kind of really have no effective zoning. And they need to be put in a zone. So the recommendation in the master plan was that they should be put, I think most, if not all, of these properties were in the A agricultural low-density zoning district before that area was designated to Senior Citizen Village. So the recommendation is pretty simple, to basically place them back in the A zone from which they came. And as you can see, it's also would be consistent with the zoning that adjoin those or that are on, in surrounding those properties in the surrounding areas. You can kind of see on that figure 1 how that A zone would basically be extended across the street to include those properties. So that's the first. So I'll stop see if there's any. It looks like Mr. Mettler may have a question.
I do, in a way. I noticed that some properties on the other side of Metlers are going back to RR3.
No, that's not a change. The
Yeah.
only change are the lots that are identified.
Right.
Yep.
But I guess my only concern is this, that most of these lots would not be conforming with the A zone.
it's,
So we're setting up a situation where each of these property owners would probably have to get a variance to do almost anything.
well, yes, that's a very good question. And I think the answer to that is there's really no good solution to that. That was the situation that they were in back when before, well, first of all, this helps the situation because right now they're really non-conforming, really almost in terms of use. There really is no applicable standards. At least this would put them in a zone where single-family dwellings are permitted.
Yeah.
So that solves the use problem. It doesn't create anything new. So this isn't making them more non-conforming than they were before this ordinance is adopted. And there really is no other zone. We can't sit here and spot zone this property, you know, like one I think might be less than an acre, you know, so we can't make that property R20 and the next one R40. You know, you can't really zone that way. So, you know, my opinion, really the only logical thing to do is, again, to place them back into the A zone from which they came. And they were non-conforming in terms of, some of these are probably not conforming in terms of lot area, probably in terms of setbacks, et cetera. But you're really not changing anything, and you're not making it worse. In fact, you're slightly making it better from a zoning perspective.
Yeah, I mean, at least there's some bulk standards, right, in the A zone, like you said,
Yes.
for a single-family house or whatever you. And if it was something else, then you'd probably want to hear it anyway.
Okay, very good.
Well, I would still feel it better to put them in a zone that more accurately describes the size of the lots. I mean, back before Canal Walk, at least some of them actually had a farm attached. And whether or not that was a separate lot, at least, well, even under the merger doctrine, they might have been considered to be the same lot. But now, none of them are really able to conduct farming. So the A zone is not really appropriate in that sense, as well as they will all be non-conforming in size. I would suggest something like, say, R40, which should make at least some of them conforming. Just in the sense that, in effect, that's the way they are developed.
We could come up with, I think, if that was a large enough concern of the board, we could explore other avenues. I think some of the lots, like Lot 5, that's at the corner of Weston and Schoolhouse, I mean, that's certainly 6 acres in size, you know, a lot larger than.
Oh, yeah.
And then lots 8 and 9, I'd have to look at that to see if those approach 6 acres. As far as the other lots, we could, rather than change the map to put them in specific, you know, lot-specific R40 zones, we could amend the senior citizen village zone and say something to the effect that isolated lots not part of the development are subject to the R40 zone requirements.
Yeah,
Something
but
to
you
that
wouldn't want
effect.
Lot 5 developed at R40 if you could help it.
No, my suggestion would be, sorry if I didn't make that clear. My suggestion would be Lot 5, for example, put that in A.
Mm-hmm.
Perhaps 8 and 9, but I have to look to see what would happen there. But the smaller lots, 6.03, 4.01, and the remainder smaller lots, say that those, keep them in the SCV zone, but add language in the text that says that they're subject to, those isolated lots are subject to the R40 zone standards.
Could do that.
I don't want to, but I don't want to have the zoning map have these little
Right.
lot-specific. That's just not the way to do it.
Months on it. Yeah.
Yeah, well, if you were doing them A, you'd still have little pockets.
No,
of
'cause the A-
around the edge of
No, because the A, this,
SCV.
no, the A, this map shows the A just gets continued across.
Oh, I see, yeah.
But if the board, I mean, that certainly is an extremely reasonable concern, and I think the solution, I think that would solve that issue if that's the route the board wants to go.
Yeah, I'm fine with it. I mean, what I would do is make sure that Lot 5 is A. Check
Yeah.
out lots 8 and 9 and see if they qualify for A. And then the rest of them, like you say, do the amendment for SCV.
Okay, and then as far as this issue, so this is, obviously, this is a draft. You know, as our usual practice, it's coming before you first, before it gets introduced by the council. Do you want me to bring this concept back to you, or do you want me to, make these changes and introduce it, and, have it go to council first? What's your pleasure?
Well, the only thing we seem to not know about are lots 8 and 9, and I think the direction of the board, if we are in agreement, would be if those qualify for A, to put them in A. If they don't, to put them in the SCV amendment, and to put lot 5 in A and the rest like we just talked about. So I think, with that direction, you probably don't have to bring it back. I would be okay.
Okay.
I don't.
That makes sense.
Okay. All right, moving to the next one. I think this one should be about as straightforward as it gets. There was a recommendation specific to this property and then general, that properties that were preserved open space or preserved farmland be put in the appropriate low-density zoning district. Lot 1.03, which is at the southeast corner of Metlers and Weston, was acquired a few years ago by the county for open space. So the recommendation is to take that out of the, I think it was the ROL zone, and put it in the A zoning district to reflect the fact that it's now preserved. Questions or comments on that?
Makes that straightforward enough.
Vince?
All right, and the last one is in the neighborhood at the end of Gates and Ellison Roads. The master plan recommends that the majority of that neighborhood is in the R40 zone, which is 1 acre lots. I really think this is a zoning map error that's just been on the books forever. For whatever reason, the absolute end of both of those roads, the properties at the end are in the R20 zone. Most of them are undeveloped. I think one may have a house on it. They're in the R20 zone, which frankly, from a planning perspective, makes no sense. I don't know why this is a pretty discrete little neighborhood, why 95% of the neighborhood would be in the R40 and then just the end would be in the R20, especially since the end is actually the most environmentally constrained portion of the neighborhood because there's a stream and some slopes back there. So if anything, you'd want them to have larger lots. So the master plan re-examination recommended that those be put in the R40 zone, like the rest of the neighborhood. So that's what's reflected in the ordinance and reflected on the exhibit in Figure 3.
Yeah, that's Sealy's Run, right?
All right.
Not Sealy's.
Which run is it? Somebody's run.
Oh, the stream.
Yeah.
Is Sealy's Brook.
Yeah, it starts in back of Sampson G. Smith and goes to the canal, right? There's under the canal, goes to the...
I will, with regard to that other, the lots 8 and 9, I'll look into that. At the next meeting, I'll report back to the board, let you know what I found out and what was ultimately recommended. Obviously, the normal course of action, this is going to go to, this ordinance will go to council, it's going to get introduced, then it comes formally back to you to do, your consistency with the master plan. So that's the process.
Sounds good. Let's see. We don't have another meeting this month, is that right? All right, so the next meeting would be February the 6th. All right, and I guess you'll let us know if we have an agenda for that meeting. Okay. Well, that's all I have.
February 6th?
February 6th, yep. Just rip off that calendar sheet there and put it on your fridge. We should get a magnetized calendar made. How about that? Next year we're gonna go classy. All right. Motion to adjourn? I'll move it.
Second.
All right, all in favor?
Aye.
Good night.